Hey there, Scott Shoemaker here. I am an estate planning attorney in Cedar Rapids, Iowa, and I wanted to talk today a little bit about witnesses in estate planning, particularly witnesses as they relate to wills. You'll recall that a will in the state of Iowa needs to be witnessed by two individuals. And this basically means you have to have two people there to watch you sign the will. And the whole purpose behind this is, of course, to provide evidence that your signature is in fact your signature, since a will has no legal effect until after you've died, and so you wouldn't be there to authenticate your own signature. So the question becomes, do the witnesses have to show up to court in a court proceeding? And theoretically, maybe, is kind of my answer. But from a practical standpoint, no. First of all, there aren't generally that many contested will type proceedings. Normally the will is what the will is. Most people are pretty equitable and fair about how they divide their assets up, and so they they don't really get into it too much. So there's not really that much of a contest. But the fact of the matter is, even if there were a contest over the authenticity of the will, normally a well-crafted will includes a separate additional document that is designed to avoid having to drag your witnesses into live court. Normally, a well-crafted will is going to have an affidavit attached to it. An affidavit is simply a sworn statement, and that affidavit basically says that the signatures on the will, both the signature of the testator, the person making the will, and the signatures of the witnesses are authentic. And so everybody signs the will, everybody signs this affidavit, and the affidavit then is typically notarized. What that does is it provides adequate evidence to the court, typically, that the signatures on the will are authentic and nobody has to show up to testify.